Okay, good morning everyone, and thank you very much for joining us today. Today our webinar is on immigration post the end of the transition period. Thursday the 23rd of June 2016 seems a dim and distant memory now, the date when the UK voted in the referendum to leave the EU. Quite a lot's happened in those last 4 years, and discussions about that transition period are obviously still ongoing, and I think they probably will be until the 11th hour. My name is Kyra Cordrey. I'm the commercial director here at PageGroup, and I'm delighted to introduce our experts today from Lewis Silkin, the legal firm whose ethos is to strive to do the best for their clients, their people, and the communities in which they operate. We're joined by Shalina Crossley, who is a partner in their employment and partnership practice, and Naomi Hanrahan-Soar, who is managing associate in their immigration and global mobility practice. There will be a Q&A at the end of the presentation, but please ask questions as we go along. I know we've had a couple prior to the webinar, which is great. And we've also included a couple of polls to help shape the conversation. There's quite a lot of content that Naomi and Shalina have, and so if for some reason we don't manage to get through it all, we will absolutely send on the presentation, but also the answers to all the questions so that you receive all the information that you need to. But before I hand you over to Shalina and Naomi, we have our first poll, which is how many of you are prepared for the changes from an immigration and employment perspective?
Well, I think the results are in, and I think they're slightly better than I would have anticipated, to be honest. It looks like 66% of you are partially prepared and 28% unprepared, 6% fully prepared. Certainly, we in the immigration team have been getting a lot of questions around what's going to happen from the 1st of January from a lot of our clients and new clients. And I think despite having had the 4 years, with all the confusion and ups and downs, perhaps a lot of people have felt less prepared coming up to finally the end of the transition period than you might expect. So that's very interesting. And hopefully you guys find these interesting as well. These poll questions are kind of aimed at making sure that you can get a snapshot of the market as well.
Fab. So without further ado, shall we crack on with our agenda? So just to give you an overview as to what we're going to cover today. So Naomi, who is our immigration expert, is going to take you through the key sections of the new immigration system. So hopefully by the end of this session, you will be fully prepared, or at least closer than 66% of you. And then I, towards the end of the session, I'm going to cover some of the employment issues that we are seeing arise when staff are asking to work abroad, either temporarily or permanently, and I'm sure many of you will have received those requests. So, so without further ado, let's kick off with Naomi. So over to you, Naomi.
Thank you very much, Shalina. So if we can move on to the first slide for immigration. So the first thing that I wanted to quickly cover, and as Kyra's kindly introduced, all of this is going to be at a very high level. The details in immigration are always very important, but they are very pernickety and they don't make for a good seminar, and they certainly make it impossible to cover everything that we need to cover. So if you'll bear with us as we go through on a really high level summary through it all, so that you hopefully get all the highlights and know what to look for. The visitor visa restrictions are really important to remember, and that's because from the 1st of January, EEA nationals will need to be part of the visitor restrictions. They will no longer be able to work in the UK without a visa permitting work, regardless of how short that visit may be. And equally, British nationals travelling to the EEA will be under the same restrictions. If you'd like more details about that, we have a seminar with Lewis Silkin on Thursday, the 10th, and some of our partners from Use Laboris around the EEA to discuss what those restrictions are and what work visas you might be looking at. But because that's a whole other topic, we're going to save that for Thursday. Please sign up if you want more details on it. So for the EEA nationals who are coming to the UK to visit, one of the main things to remember is that the visitor visa does not permit work. It's very confusing because they don't specifically define what work is, and they then go on to provide a number of permissible activities, which includes things like business meetings. And if your day looks much like mine does at the moment, sometimes it feels like business meetings is about all you do for work. So sometimes that line that needs to be drawn on whether something can be a visitor visa or requires a work visa can be quite difficult to determine. Hopefully, you're able to look at people having quite short visits where they're very clearly still employed abroad, they're not being paid by a UK entity, and it is just a few meetings that they're coming for before returning home. Whenever something gets a little bit borderline, it's certainly worth either checking with an immigration specialist or providing some advice to the individual themselves to ensure that you have a paper trail of trying to ensure that they remain within the restrictions of the visitor route, remain compliant, and you as an employer can't be seen to be employing them to work illegally in the UK. So if we can move on to the next slide, we'll talk a little bit about some of those work visa options. So the most common work visas under the new immigration system, which despite the fact it technically and legally starts from the 1st of January, has been open for applications from the 1st of December. So the most common visa categories are the skilled worker route, which replaces the Tier 2 general route and is largely the same with a few key changes that I'll go through with you. The ICT or intra-company transfer routes, global talent, which is less common but still very useful for those that it does apply to and broken down by industry such as tech, architecture, creative and so on. That's one that's largely aimed for the individual to apply for, so we won't go through it in detail today. Similarly, the others that you might come across, but which we won't go through in any detail today, are Tier 2 sports person, temporary workers, ancestry visas, innovators, sole representative visas, and youth mobility. And I think in the future, we will certainly find the youth mobility visa becomes more useful because that is aimed at anybody under 31 who comes from certain nationalities. And you're probably familiar with it as the working holiday visa. Australians, Canadians, Kiwis, frequently on that one for 2 years in the UK. It is capped, and that will be dependent on reciprocity. So one of the reasons why you probably have come across a lot of Australian nationals with that status is because British nationals tend to like to go to Australia for a similar working holiday visa. So there's a larger cap for that nationality. And the intention has always been that EEA countries will come under that scheme as well, but that is something that is part of the withdrawal agreement. So it hasn't been put into the rules as currently drafted and already open for the 1st of January, but we do expect that it is likely to come into force sometime next year. So moving on then to the next slide and the skilled worker route. This is by far the most common work visa in the UK. We're talking many, many thousands. There are roughly 30,000 sponsors on the register already, and that number is only increasing as companies who didn't need a sponsor license previously need one going forward because EEA nationals will be utilising this route as well. The really key changes since the 1st of December is broadening this route so that it becomes more useful potentially for companies and individuals. And that's because previously it had a minimum skill level of RQF6 and a minimum salary level of just over 30,000. Now the minimum skill level has been reduced to RQF3 and the salary to 25,500. To put that into context, one of the most commonly used categories within that route is a business development manager. And under the old system, you would only have been able to utilise that if the person was at least a managerial level or above. going forward, a sales account manager could also utilise it. So you're looking at a significant drop in the minimum skill level, but it will remain to be seen how many people use that given the cost of the route, as we'll go on to. The useful thing with a skilled worker visa is that it does lead on to permanent residence or indefinite leave to remain in the UK. So it gives people the option of setting up their life here permanently, and that makes it far preferable to the ICT route, which does not lead to permanent residence. However, the skilled worker route is employer and employment specific. If anything about the employer or the employment changes, then the individual is likely to either require an entirely new visa if it is a significant enough change, or there are reporting duties for the sponsor. And those reporting duties are really important because they tie into the compliance requirements. And without compliance, the sponsor is likely to lose their license and thereby lose their ability to bring in workers from outside of the settled labour market. So on to the next slide. Yep.
Sorry to interrupt. We've just had a question through actually about for current EU employees working in the UK, do they have to have applied for settled status by the 30th of June next year, or do they have to have received settled status by the 30th of June?
So the wording is that they have to have applied for it by then, but it will be very difficult practically for them to live and work in the UK after that date if they haven't applied, if they wanted to change employment, for example, because after that date, their employer is going to need to see that they continue to have the right to work in the UK, and without having their settled status, they won't be able to evidence that. So I'm going to go into a little bit more detail on that because it does become a little bit of a complicated question for employers, and it's a really hot topic at the moment for a lot of reasons. It also ties into some of the questions we had in advance of the session.
Okay, brilliant. Thank you.
Thank you. So the helpful changes under the new system for the skilled worker, anybody that's used it before will know and hate the resident labour market test. 28 days advertising that was incredibly futile, and in 14 years of doing immigration, I've only ever seen an employer hire somebody else once. That's because you've generally already identified who you want, and the way that you needed to advertise it, including the government website, didn't tend to attract the best people anyway. So the Migration Advisory Committee recognised that fact and advised the government that it was a pointless waste of time. They listened and they have removed it. So hurrah to that, we have at least a month less in the lead-in time to getting a skilled worker visa. Equally, there is currently no cap, whereas we did have the cap before, and some people might remember a couple of years ago when the cap was met, and it created quite a lot of chaos because you couldn't then predict how quickly somebody could come to the UK because you couldn't predict when they would be able to meet the minimum points for the cap, because what happens is the points would then go up and down. It is paused, however. The government have said that it's still a tool that they may be able to use if they feel that the route is being overused or migration gets too high. So skill and salary thresholds have been lowered. There's no cooling off period if you've come across that before. This also means that people who are on an ICT visa are now able to switch into the skilled worker in order to start their route towards permanent residence in the UK. And there's no longer a monthly application process when applying for a restricted cause, which again effectively really just means there's less time involved before you can get a visa. And one other thing which may be helpful for those already in the UK or still to come who have ownership in the company that they intend to be sponsored by, there used to be a restriction that you couldn't have more than 10% of shares in the company. That's now been removed. So that enables those people who don't fall under some of the more entrepreneurial visas available to utilise the skilled worker visa if they need to.
Okay. Naomi, sorry again to interrupt, just clarity on the previous slides. All work visas, are they all granted for a 2-year period? And does this mean that someone on a skilled worker visa will get indefinite leave to remain after 2 years?
No, not at all. Most visas are granted for significantly more than 2 years. The length of the skilled worker visa is determined by how long the certificate of sponsorship is issued for, which is dictated by what the employer wants. So they could request 6 months, they could request up to a maximum of 5 years. It affects the total cost of the visa. And it normally takes a minimum of 5 years in the UK to apply for indefinite leave to remain, provided that 5 years has been both in a visa category that leads to permanent residence and in a combination of categories that can be combined if you're looking at multiple visas.
Okay. And then we've just had another question through that's slightly different, and it's talking about if a business or activity transfers under 2Pay, would sponsorship and the right to work transfer with business transfer?
So it's a fairly complicated question and how that works. It will depend on who's holding the sponsor license after 2P and where the change in ownership at the corporate level has occurred. Generally speaking, in most circumstances, a 2P is going to trigger the need to either apply for a new sponsor license, because if the entity that holds the sponsor license has had a majority change in ownership, their sponsor license becomes invalidated by that and they need to apply for a new one. Or it's going to mean that they're going to be transferred to another license within the corporate group, depending on what that looks like. And in either circumstance, once the license issue has been sorted out, an application to the Home Office is required to transfer sponsorship. And those ones can take quite a long time for them to process because they find them complicated, though you are able to function as though it's been approved in the meantime, assuming that there's no reason to think it won't be. The right to work checks are something that you then inherit liability and protection from the right to work checks, which have already been conducted. So it can be a good thing, it can be a bad thing, depends on how good they were conducted previously. Hence, they should always be part of the corporate due diligence process. You have 60 days after acquiring an employee via 2P to conduct your own right to work check to give yourself valid protection that you can then be more certain is completely reliable.
Okay, brilliant. Thank you.
No problem. Next slide. So the bad news with the skilled worker visa is primarily really the cost. There's a huge amount of time and onus and responsibility for the sponsor, but the cost is really the most prohibitive factor. So for the average 5-year visa, which is the amount of time that it takes to lead to indefinite leave to remain, it's going to cost you only just under £10,000 for the main applicant. That's before you have any dependents. And that's why lowering this minimum skill level and salary level may be something of an academic exercise in a lot of circumstances, because if you're looking at somebody who's only being paid £25,000, chances are that you're not really likely to want to pay an extra £10,000 for their visa. And I think what we'll find is that a lot of employers will put a sort of internal policy in place for what level of employee they wish to sponsor. Next slide. So ICT route, we're going to go through very quickly, but that one is there as the temporary, what used to be tier 2 skilled worker route. It's there for those people who've already been employed by your corporate group, but outside of the UK. Because it's temporary, we tend to always advise people to try to use the skilled worker category anyway. In my experience, people 9 times out of 10 change their plans or reveal plans to stay in the UK that perhaps they'd had kind of simmering in their minds anyway before the move. So the business might require the person to stay longer, the individual might find roots and settle in the UK and wish to stay longer. 9 times out of 10, the ICT route ends up being a prohibitive factor in that. So you want to just get onto the skilled worker route straight away. And now with no RLMT, no restricted COS process, there's no particular advantage to the ICT, because its main advantage previously was that the lead-in time to get it was significantly less. Now, really, it's only useful if you're looking at somebody who is genuinely coming to the UK for a very short period of time between corporate entities and one international corporate group, and with no intention of staying any longer. So in order to get onto some of the other topics that I know you'll probably find more useful, I think we might skip through the next 2 slides of ICT. So processing times for the skilled worker visa generally have reduced significantly. You're looking at really only a few days in the best of circumstances to prepare the application, standard processing time of 15 working days when submitting an application outside of the UK, 6 to 8 weeks inside the UK. You can pay for various levels of priority processing, which can reduce processing from about 24 hours to about 5 working days, depending on which level of service is both available and paid for. And at the moment, it's availability that is the issue, because with local lockdowns and the COVID-19 backlog, a lot of places around the world don't have the option of priority processing. So ideally, we would always advise instructing your immigration advisors around 2 to 3 months before you need the individual, because that gives plenty of time for preparing the application and working around any travel plans they would have under normal circumstances when people can travel. But when somebody is required urgently, they can obtain their visa within 2 to 3 weeks, provided everything is there and runs smoothly. And on to the next one. So again, a whistle-stop tour, but sponsorship compliance is really key now. It's always been an important issue, but with EEA nationals also needing to utilise the skilled worker route, you're going to find that your compliance is of ultra importance. If you lose your licence, then you can't bring in people from outside of the UK to work most of the time, because this is the visa that you will need to rely on. So it's really important to consider it. The Home Office do aim to audit all sponsors at least once every 4 years, and audits are often unannounced, particularly if they want to check the genuineness of the business. There's a number of different categories of compliance that apply, and the really scary one is probably genuineness, because you could almost call it the something smells dodgy test. They can apply that whenever they want, however they want, and because the sponsorship regime is considered effectively a club that you do not need to be part of if you don't want to be, there's a lot less room to appeal a decision to revoke a license. So prevention is absolutely better than a cure in this circumstance. On to the next slide. Right to work checks. Now, this is, I think, probably what a lot of you are really interested in, and this is where we've had a few questions in advance of the presentation as well. Right to work checks are looking at 2 different offences. There's a civil penalty of £20,000 per illegal worker found, and that's assuming that you didn't knowingly employ the person to work illegally. There's also a criminal offence where somebody should reasonably have known. So not that they actually did know, but that it can be surmised that they should reasonably have known in the circumstances that somebody was working illegally. And that one leads to an unlimited fine and up to 5 years imprisonment for the person that is deemed responsible. So that one is by far the scarier one, but certainly employed a lot less regularly. The £20,000 fine is actually quite common. There's a public register where you can see businesses that have had that fine. It's published every quarter and on a regional basis. Now, the defence for the civil penalty for the £20,000 fine is to show that you have a 100% compliant right to work check. If you can show that you have a 100% compliant right to work check on file, and that includes the follow-up checks where those have been required, and it again, like all things immigration, is a little bit pernickety. You have to tick every box. If every box is ticked, then it's okay. If not every box is ticked, then it's not going to be considered compliant. If you have that, then that will automatically get you off the fine. If you don't have a 100% compliant fine, then you'll have to go into a process of evidencing mitigating factors and being able to potentially reduce the fine. If it's your first fine, you might be able to get it down to 0, but if it's not your first, then it would only be able to be reduced to 5,000 as a minimum. And that will also feed into your sponsor compliance. So if you receive a civil penalty for illegal working, if you have a second one, it means that you automatically should have your license revoked. A first one may have your license revoked depending on the circumstances. Right to work checks have to be applied to all employees. It's really important to make sure that it does, both to avoid any potential discrimination claims, but also because it is really easy to assume that somebody is British when they're not. And if we move on to the next.
And Naomi, sorry, there's another question here that's come through. If your license was to be revoked, can you reapply for a sponsor license further on down the line?
It's going to depend on the circumstances, because if it has been revoked for compliance reasons, then sometimes you're going to have a cooling off period, which can be up to a couple of years before they will allow that business or that authorising officer to be on a licence again.
Thank you.
So in order to make sure that you're doing your right to work checks compliantly, you've got to be looking at making sure it's done before any new employee starts work. You also need to make sure that there's a follow-up right to work check for somebody who's on a temporary right to work, such as a visa. EEA and Swiss nationals have until the 30th of June to obtain their EU settled status. But from the 1st of January next year, they must, if they don't qualify under the settled status scheme, have a work visa. So this puts employers in a very strange situation where the government have told them their right to work checks remain the same until after the 30th of June, but they might be taking a right to work check for, say, a French national based on their French passport, which meets the right to work check requirements. But that French national has only just entered the UK, doesn't qualify under the settled status scheme, has not applied for a work visa, doesn't qualify under any other kind of work concessions, and therefore is actually working illegally when they start work for them. Now, in the civil penalty circumstance, if they have a compliant right to work check on file and that person is later found to be working illegally, they will be able to present their right to work check and be excused of the penalty. But what we're finding is that quite a lot of employers aren't comfortable with this situation anyway, and they would much prefer to be able to see something which they know is giving that person the right to work, either settled status or a work visa. Now, the Home Office's assurances have been that you do not need to recheck existing employees that are European nationals. You do not need to change how you do your right to work checks until July, and so not to do so. And in fact, under the right to rent scheme, their guidance is quite clear that you cannot insist on a European national presenting settled status until after July. So what do you do if you really want to find out that somebody is holding a right to work after the 1st of January? Well, you do need to be very careful of the race discrimination issue and of the fact that you're asking people for sensitive personal data, which you don't have a legal requirement to request. So if you suspect that person may be working illegally, that brings you into a different territory, because at that point you may be looking at the criminal offence of knowingly employing somebody to work illegally, and then you potentially do have a good business reason for asking for those details. But it is something to not undertake lightly, because you don't want to be forcing European nationals to show you a settled status before they're legally required to have it. So it's a delicate position to be in, and one I think that is best only undertaken with additional advice if you're going to go down that route. But that should hopefully give you an idea of the framework that you're working within. Now, right to work checks at the moment have a few concessions around how they can be undertaken, and that's specific to the COVID situation. So from the moment that the lockdown started, they put out additional guidance to say that instead of having to see the paperwork in hard copy original, so instead of having to have somebody send you their passport for you to hold whilst you then had a video call with them, you could actually view that over a video call and scanned document. So that concession continues for the time being. The Home Office have indicated that at some point they will lift that restriction and insist on, sorry, my cat is jumping onto me. They will lift that restriction and then insist on the checks being retaken for those people that have had the fully online check during the lockdown. That may change because they have seen how well it has worked and how much employers have enjoyed the freedom of being able to do it that way. It's very practical. And with the new immigration system, they have allowed a lot of things to go digitally. So we're hoping that that will change. But for the time being, you still need to keep those records. And let's skip through. Okay, so I think Kyra is going to take us through another poll.
Yeah, we have another poll. So have you already checked the settled or pre-settled status of your existing employees under the EEA free movement? Yes or no?
Naomi, while we're waiting to see the results, I noticed there was another question which I hope you might be able to help with. So is applying for settled status different to applying for permanent right to remain? Is it a different residency type?
It is. We have three different permanent statuses in UK immigration law. You have indefinite leave to remain, or ILR, which is for those people applying under the immigration rules. That's predominantly for pretty much all other visa categories than European. So ILR is for spouse of a British national, people under a work visa, etc., etc. Permanent residence is under the EEA regulations. That's for European nationals who have applied generally by post, generally by submitting a number of documents in support. And that one's different to settled status because A, it's under the EEA regulations. So those people who have permanent residence need to convert it to settled status in order to come under the settled status scheme. And B, permanent residence would be dated. So if somebody had lived in the UK for 10 years consecutively, they would have acquired a right to permanent residence 5 years ago. And that is useful if they want to become British, because you need to have held permanent residence for 1 year in most circumstances. Settled status is the new form of permanent residence for EEA nationals as part of leaving the EU when the EEA regulations no longer apply to us. So if not looking to become British by the 30th of June, somebody who has permanent residence needs to convert that to settled status. And I think we've got our poll results in. So 64% of people have not checked settled or pre-settled status for existing employees, but 36% have. And I think that is really interesting, given that you don't have to check it. And that kind of correlates with what I've been seeing as well. We actually have a second poll now to see who wants to check going forward, particularly after the discussions we've just had. So will you be asking your employees to show you their settled or pre-settled status, yes or no?
While we're waiting, Naomi, I wonder whether you could answer this question which has come in. So, will organisations who previously didn't have a licence now need to hold a licence if they are employing EEA nationals?
Only if they want to be able to sponsor new employees that are EEA nationals. If you already have EEA nationals working for you in the UK, they would qualify for pre-settled or settled status. They would need to apply for that themselves, and that status doesn't require sponsorship. So provided they do everything that they need to do, they'll be able to continue working for you without interruption, and you don't need the license for that. Wow, okay, so the poll results for this one is that 65% of you will be checking the settled or pre-settled status for your existing employees going forward. So I think that's quite telling that employers really want to be compliant regardless of what the requirements from the Home Office are. So we're moving on to Shalina's section of this presentation, so I shall hand over to my esteemed colleague.
Thanks, Naomi. I know there are some immigration questions that have been asked in the chat. We'll do our best to either pick them up at the end or after the session. So don't worry, we haven't forgotten the questions. So moving on to the new normal, which is this buzzword that everyone is talking about, and looking at that in the context of requests to work either temporarily or permanently abroad. So post-COVID, there are about 10 times more people working from home than there were pre-COVID. And our experience is that employers have received more flexible working requests than they ever have. And those requests have included requests to work temporarily or permanently from home. And many have included requests to work abroad, particularly in these COVID times where people, want to be with family or, for example, have been stuck abroad. And in the long term, I think that this is going to be the new normal. We are going to have a much more agile workforce. People are going to, work abroad more. They'll work from different jurisdictions. There'll be much more. There'll be increased agility, I think. And I'm sure Naomi will have something to say about that in terms of the immigration implications. But it's quite interesting, I think, that if you look at some countries, they are trying to get ahead of the curve on this issue. So, for example, Barbados Antigua, Dubai, they've all introduced this concept of, a digital nomad visa, where the current barriers that are in place, which we are going to talk about, so, the barriers to working abroad, such as immigration, tax, social security, etc., those jurisdictions have essentially said, well, don't worry about those issues. We'll pick up the fallout from those things, because I think they recognise that, having people who are going to be in their economies, kind of spend money, will actually kind of outweigh the disadvantages to picking up those issues. So it will be really interesting to see if other countries follow similar suit. But for now, employers need to be really mindful that permitting employees to work abroad, comes with it, a number of issues which, really ought to be considered in detail. And I'm talking about these kind of temporary arrangements, as opposed to, more long-term, established arrangements, such as, secondments, which will continue in the normal way. So, Kyra, if we move on to the next slide, we can look at really what should employers have in mind. But before we do, it would be really interesting to know how many of you are anticipating permitting your staff to work from overseas when life returns to normal. So either permanently, temporarily, or no, absolutely not. So cast your votes now.
And whilst the poll's taking place, we've got a question here saying, please can we clarify the situation for Irish nationals?
Irish nationals are very special. They get their own agreement that's prior to the UK joining the EU, so they don't need to change anything. Irish nationals are considered settled as soon as they step foot and reside in the UK. They're completely exempt from the requirements, completely free to come live and work in the UK.
Thank you.
Thanks, Naomi. So I think the results are in. So some 8% permanently and 92% temporarily. So I think that's really interesting, because it shows that actually employers, I think, are anticipating that this is going to be the new norm. And it's quite interesting that no one is thinking of adopting a blanket policy of just saying no. My experience is that actually during the COVID period, we have seen some employers just not prepared to address their minds to the issue, largely, I think, from a cost perspective, and the reasons for that will become clear as we talk through the issues. So let's go back to the slides, and let's look at what employers really should have in their minds. So it really falls into 3 categories. So immigration issues, so, can the employee actually legally work from the host country? The position, as Naomi said, is going to change from the end of December, and there are going to be further restrictions on travel and working abroad. What are the issues when an employee who's already been working abroad returns to the UK, and will their rights be protected when we no longer have the same level of EU legislation? The second bucket is tax and social security. So, what are the employer's continuing obligations in the UK in respect to PAYE? Is it possible that the employee's stay creates some kind of income tax or social security liability or withholding obligation for the employer in the host country? Is there a risk of permanent establishment? And that's something that kind of strikes fear into every employer's heart, because, corporation tax can be incredibly expensive. And then there are a basket of other considerations. So employment considerations, will somebody benefit from the mandatory rights in the host country? What is the impact on any UK benefits that they have? Is there a data protection issue, because there'll be the transfer of personal data between different jurisdictions? And health and safety. So we can't forget, particularly in these COVID times, that the employer has a duty of care to employees, and that will extend to those who are working abroad. So let's have a look at these issues in a little bit more detail. So if we move on to the next slide, I won't profess to be a tax expert, so I'll do my best to answer any tax questions, but I might have to come back to you on them. So I'm looking at tax from a UK perspective. The first thing to bear in mind is that where you send somebody abroad, as the employer, your obligations to operate PAYE in the UK will still continue. However, there is a general rule that an employee must pay tax in the country in which they are physically working, unless an exemption applies. And the exemption is where a double tax treaty with the other jurisdiction is in place. Now, there are particular criteria that need to be satisfied. I've simplified them here, so do take further advice if you're thinking of doing this. But the criteria in essence are that the employee's got to be tax resident in the UK. The employee can't be spending more than 183 days, or about 6 months, in a 12-month period outside the UK. And there are various different rules about how you calculate that 12-month period. And the company must not have a permanent establishment in the host country. So if no exemption applies, the employee might end up being taxed in the host country and in the UK on their worldwide income, although they should get some credit in the UK for tax paid in the host country. So you can see that actually, before you even think about agreeing a request for working abroad, you need to take some tax advice in the UK, but also in the host country, because otherwise, let's be realistic. The tax authorities always come after the employers, even though the obligation to pay income tax is the employees. So it's really important, I think, to take some advice before you embark on an arrangement like this. So on a related note, then let's look at the next slide, where we consider the social security issues. So from a social security perspective, the UK divides the rest of the world up into 3 categories. So the EEA in Switzerland, any country that's got a reciprocal agreement in place, so countries like Japan, the US, Canada, Korea, and then the rest of the world. So what are the rules for the EEA in Switzerland? So the current rules are that the employee and the employer pay social security in the country where the employee is working, unless the arrangement is a temporary posting or the employee is working in 2 or more countries and an A1 certificate is obtained. After Brexit, the UK says that it will continue to adopt this approach, but it remains to be seen as to how other countries will deal with this issue. So then the second category is the reciprocal agreement, where the employee and the employer pay social security in the country in which the employee is working, unless, again, the arrangement is temporary and a certificate of coverage is obtained. And then we've got, lastly, the rest of the world, where the employee and the employer pay NICs in the UK for the first 52 weeks. So my advice would be, for a short-term temporary arrangement, it's probably best to continue to pay UK NICs and to apply for an A1 certificate or a certificate of coverage from HMRC. So let's move to the next slide and think about the thorny issue of corporation tax. Now, this is actually an issue that we can't look at from the perspective of the UK. What we have to do is look at the host country, and it's important to take advice in the relevant jurisdiction that the employee is going to work in. And the usual considerations that other countries consider are, whether that particular employee occupies a role which would enable them to conclude contracts on behalf of the company on a regular or a habitual basis. So what they're looking at is, really whether that employee forms, kind of part of the management structure of the firm, or is able to create liabilities for the company when working abroad. They will also look at whether the employer has a place of business, so an office or some kind of permanent place of work. And the implications is that if an employee goes abroad and satisfies the relevant criteria in the host country's jurisdiction, then it's possible that that will cause the employer to have a permanent establishment in the host country and then be responsible for corporation tax. and also have, kind of wage tax and salary reporting requirements. So you can see that you might be paying tax in the UK, but then also be paying tax on your profits in the host country, which could be, extremely expensive. So let's look at the next issue that employers ought to be aware of, the thorny issue of employment rights. So as well as having their rights in the UK, you need to think about rights that an employee might acquire when they go off to work somewhere else. So from a benefits perspective, the employee might already be part of some of your benefit schemes. So, pension schemes, private medical, permanent health insurance, those kinds of things. And it's really important to consider the terms of those schemes, because it's possible that actually the employee won't be able to benefit from those schemes when they are not working in the UK. And that then could, lead to potential breach of contract issues if there's a contractual right to participate in those benefit schemes. So the next issue to think about is the thorny issue of data protection. And if somebody's going to work abroad for a very short period of time and there isn't going to be a lot of, data transfer, then the risk is probably going to be relatively low. But obviously, the longer someone works abroad, the more work they do abroad and the more transfer of data there is, the higher the risk. So it's really important that you've got the right intra-company transfer agreements in place. You've got really robust data policies, and employees really understand the obligations that they have when they're working abroad with respect to dealing with data. So moving on to the next slide and looking at employment rights. So in the UK, the person will have their normal employment rights if they're an employee or if they're a worker, rights such as unfair dismissal, the right not to be discriminated against, etc. If somebody works abroad, it's possible, depending on how long they spend working abroad and their connection to that particular host country, that they may well acquire mandatory rights there too. So, for example, family-friendly rights, so for example, rights to take particular kinds of family leave, working time regulations, so things about, provisions about rest breaks, the amount of time that they can work, the amount of holiday that they have to have, particular they might be entitled to. And then probably the most tricky issue in a number of particular European jurisdictions is what happens on termination. And certainly in countries like France, Spain, there are particular provisions which we don't have in the UK, which would require a particular severance payment to be paid if you were thinking of terminating that person's employment. So if this isn't going to be a very temporary arrangement, you might think about localizing that employee, so putting them onto the host country, a contract that would be suitable, for the host country. And then finally, health and safety. As I said, the employer will continue to have a duty of care to employees who are working abroad. And so it's important to understand, what health and safety provisions are in place in the host country. And it's important to maintain proper lines of communication and assess risk, actually, in terms of where people are going and whether it would pose any risk to employees under any kind of government guidance. So moving on. How can we minimise the risk? So as I say, the longer the employee's abroad, the greater the risk. If somebody is going to work abroad for, a month because they've got some caring responsibilities, there might be very minimal risk, although you will want to still take tax advice and advice about social security contributions that might be payable. But the risk is likely to be less the shorter the period. Important, as I say, to take local advice. You might want to think about whether you want to implement a blanket policy, and a lot of companies, I think, are looking at this now. The difficulty, I think, with that is that actually, in order to apply a blanket policy, you'll need to understand what the tax and social security obligation and employment rights will be in a number of different host countries. And I think, on the last count, I think there's 196, countries in the world. And so, it will be very expensive to take bespoke advice for each of those jurisdictions. So you might, for example, undertake some surveys within the business to find out if people are planning on working abroad or applying to work abroad, the kinds of countries that they would be looking to move to, because then you might want to take some limited advice in those jurisdictions in order to come up then with a policy. If you are sending somebody abroad or permitting them to go abroad, you'll want to set out the terms in writing. So, you know, the length of time they're permitted to go abroad for, you know, the extent to which you can call them back if the business requires, etc. And you'll want to think about whether them working abroad is on the same terms as their UK contract, or whether you need to vary them in any way. So next slide, please. So what do you need to agree with the employee? You know, we've talked about social security and tax. You'll want to agree with the employee that they will be liable for any additional income tax or social security. And you'll want the ability, the contractual right to be able to make deductions from pay to take account of those things. You'll want the employee to be responsible for any personal tax declarations. And as I say, we've talked about the employment contract, but you'll want to think about your jurisdiction clause and whether or not it's governed by UK law, whether the employee or the employer has got the ability to sue in different jurisdictions, or whether there's exclusivity there. So moving on to the next slide. If you are concerned about the issue of creating a permanent establishment, then you'll want to make sure that the employee has no authority to enter into contracts with local customers or clients whilst in the host country, and that will be easier to achieve for some roles than it will for others. You might want to agree that the employee cannot benefit from your UK benefit scheme, unless, of course, that is permitted by the schemes. From a practical perspective, you'll want to make sure that the working hours work. So, you know, the different time zones that someone is able still to contribute to the business in the same way as they would if they were working in the UK. And you'll want to make sure that they're set up properly, so they've got sufficient broadband, they've got sufficient phone access, because you don't want to send them abroad and then for them not to be able to actually fulfill the requirements of their role. From a health and safety perspective, you might want to agree that they're working from home at their own risk, and the employer is not liable for any loss, but there are limits in terms of you know, placing those kinds of restrictions. So moving on to the next slide. You'll want the employee to agree to comply with any local public health guidance. That will give you some protection and the ability to discharge your duty of care. And then you might want to set some parameters in terms of the date that the employee is expected to return to the UK. So Kyra, let's move to the slide where we talk about what happens if you send someone abroad and they refuse to come back. Because this is an issue that we have seen crop up in COVID. So people going on holiday and then actually not being able to make it back, or people going away wanting to spend time with their family and not wanting to come back. So what can you do as the employer in this tricky situation? So if it's right that under the contract of employment, the employee's contractual place of work is the UK and they have chosen to go abroad, if you issue them with a reasonable instruction to come back, they're likely to be in breach of contract, and you may well be able to deal with it as a disciplinary issue. I think the issue becomes murkier or grayer when if you've actually agreed that they are permitted to go and work abroad, and actually that you didn't put in place sufficient parameters. So in that case, you'll want to try and reach an agreement, acting at all times within what in employment law we call the reasonable range of responses. And the reason I say that is because if you don't, then that there are potential, that gives rise to a potential claims for, you know, breach of contract, unfair dismissal, constructive dismissal. I think it's likely that if they haven't already, employees will make flexible working requests, and your obligations are not just simply to agree to any flexible working request. There are a number of reasons that are valid reasons for refusing a request, and they include things like, you know, cost, not being able to organise your business in a way to provide cover, etc. Just a note to be wary that if the flexible working request is connected to childcare, then obviously there are potential sex discrimination risks. So you'll want to ensure that you've considered the request thoroughly, you've got proper data to back up the reasons why permitting somebody to work flexibly in that way wouldn't work for the business. But there is the possibility of objectively justifying those kinds of claims. So that kind of is a bit of a whistle-stop tour through remote working and the issues for employers. I'm very happy to answer any questions. I know we're almost out of time, but as Kyra said, we will share the materials with you. Naomi and I are very happy to receive emails from anybody who's got any questions. Thank you very much for the PageGroup for giving us the platform to talk to you all.
My pleasure. Well, thank you, Shalina and Naomi. We have got time for a couple more questions, but as you say, we will send out the response to all the questions, so everything will be answered. We've had a couple of questions, and I think this is probably one for Naomi. An individual or an organisation have hired 3 people to work on a client project, but obviously at the moment the client premises are closed because of COVID, so they've started working remotely, but their remote working is from a country in the EU. What do they need to do to guarantee their right to work from the 1st of January? They came into the UK less than 6 months ago to sign their contract of employment, but they've not.
Know what nationality they are?
Doesn't stipulate, it just says EU.
So if they're European working in Europe, then obviously they're fine to continue doing that. In terms of working from the UK once they are ready to come to the UK, it is difficult. COVID has made a difficult situation a lot more challenging. And as Shalina was talking about, people that don't want to come to the UK is a slightly different issue to people that can't come to the UK. Really what you want them to do is to have had a physical presence within six months of making an application for settled status, and that physical presence having been prior to the 31st of December this year. It's all of the assurances from the government have been that physical presence is key, but actually in the rules that they published for the scheme, they do also require the person to be exercising treaty rights, which would mean studying, working, being financially self-sufficient, or within their first 3 months of residing in the UK. Now, they haven't been enforcing that. They have assured us that the reason they have that in the requirements is in order to refuse people on character grounds who don't meet the very high bar for refusal on the basis of the character grounds. But I mention it because it makes me wary that there's the possibility that somebody who simply enters the UK for an hour on the 31st of December and then flies back out again, I would be a little bit concerned that they might not be approved under the scheme because they're not genuinely intending to reside in the UK. So I think you could skirt it really tightly and just have them come in immediately before. If you know that they're going to be working, I think that's going to be fine because you'll have a job offer to evidence it. But if they're just trying to try their luck and get in for a very short visit and then fly out again, and you can't evidence an intention to stay, then I think those ones I would be wary of.
Okay. And just to wrap everything up and kind of one final question so that people on the call can go away with something, an action plan. What do people need to do from the 1st of January? What must they do in terms of organisations if they're either got individuals that are current EU nationals working for them, or if they're looking to hire?
Well, the only thing I think that they really have to do, given that the Right to Work scheme says nothing needs to change until the 30th of June, is if they have a new hire that they are employing who's an EEA national, who is open with them and says, I've only just entered the UK, I don't qualify under pre-settled, then they're going to have to obtain a work visa for them, which will most likely be the skilled worker visa.
Okay. Well, we've reached our time. So thank you very much, Shalina and Naomi, for all of your insight. And hopefully we've provided our clients with a little bit more clarity in terms of what needs to do. As I say, we absolutely will post all the questions and some answers, and the transcript and the presentation will obviously be sent out so people can follow up as and as and when they need to. But thank you very much both for everything, and thank you everyone for listening.
Pleasure. Thanks very much.
If you found this video helpful for your recruitment journey, why not subscribe to our channel? And don't forget to tap the bell to get the latest videos first.